This I know from the old people. Yakama Indian Treaty Rights as Oral Tradition by Andrew H. Fisher, as presented by Matthew McKeever for History 410. The oral tradition is not limited to those people who inhabited North and South America before contact with Europeans was made. The oral tradition is a foundational piece of Western tradition and civilization, and it has played a part in the Western understanding of our advancements as a species and our development overall. From the oral tradition of the ancient Mediterranean, we have the Odyssey and the Iliad and even the Torah. These works make it to our hands first through the oral tradition, then by the advent of the written word. In context of the article, oral tradition is a part of how knowledge of Native American treaty making makes it to us today. Indeed, governments, negotiators, translators, and the treaties themselves offer much information about the original terms of the treaty. Still, agendas influence the accounts of men who write them. The Yakama entered into a pact with the American government in 1855. Congress ratified that treaty in 1859, where the practice of congressional ratification would cease in 1871 when negotiating in bad faith, bribery, and blackmail became the norm for the American government. This in addition to violence, coercion, forced marches, and things of that nature. Andrew Fisher is an associate professor at the College of William and Mary. He received his PhD from the University of Arizona in 2003, and his areas of research include the United States, imperialism, colonialism, the environment, and Native American people. His book, Shadow Tribe, explores American indigenous and environmental history. Unironically, much of his research includes interviews with tribal elders and the keepers of oral records for the indigenous. Because he grew up in the Pacific Northwest, he developed an interest in the area's history. Consequently, his interest in the oral history of the Pacific Northwest indigenous peoples was likely born from his experience with those interviews and his personal experience in the geographical area they inhabit. Fisher's thesis is the Yakama understanding and transmission of knowledge of their treaty rights and their obligations within that treaty were initially shared through the oral record amongst themselves by those in attendance of the council held to negotiate and consider the treaty. The differences between the orality and literal versions of the treaty bred opposing interpretations of the original treaty. The oral and written records are significantly different from the differences in the conceptualizations of language between the disparate people involved. For example, and we'll discuss this a little more later, that the meaning of memorizing line by line or word by word holds substantially different meanings when discussing the oral tradition versus the written tradition. The mountain of written records at our disposal makes the Yakama case very interesting. Minutes of tribal councils taken by clerks, transcripts of Indigenous American negotiations, and letters between negotiators and government officials in Washington, D.C., as well as legal testimony by Indigenous in American courts. His research is unique because of his hyper-focus on where oral tradition and written record intersect. He then takes a look at the differences between the oral tradition and written record, as if it wasn't obvious enough. He explains in detail the differences in the epistemology between oral and written records, how the written word transformed the transmission of history and knowledge between generations, before discussing the direct significance of the Yakama oral record and the meaning of treaty, as well as their understanding of it. In this argument, Fisher discards the popular notion that the indigenous were gamed or played or duped by the Americans because of their superior intellect, and he examines the reality of bad faith negotiations and amendments the government made to the treaty after they had already been signed. Additionally, he offers that inferior translators of the government as an alternative explanation for the deviation between what the treaty stated and what the Yakama understood it to say, as well as the oral record as they transmitted it later. The interpreter for the government was non-Indigenous, and he likely grasped for words that accurately communicated the terms or not, and in either case was unsuccessful. The possibility for mistranslation is significant because the Akama could not read the treaty for themselves immediately and had to accept the translator's version of interpretation to make their decisions. Fisher then gets into how and why the phrase, "as long as the sun rises and rivers flow," shows up in the oral record, and how contemporary research casts the notion aside as fanciful or romanticizing of Indigenous tradition and memory. In 1908, there is a record of the phrase. That Governor Stevens used that phrase to describe the length of the treaty and the term of it to be as long as the sun rises and the rivers flow. That was not the earliest mention, however. Chief Willie Charlie said in 1893 that he had heard it himself, that the governor had said that, but he had to admit that he nor anyone else could find the phrase in writing. The absence of written evidence was enough to have the notion repudiated entirely. Chief Willie Charlie also mentioned Governor Stevens' use of spiritual language and symbols like Heavenly Father, or he'd make a show of gesturing to mountains and rivers and streams and the ocean and other landmarks that were spiritually significant to the Indigenous as a means of eliciting support for them to accept treaty. Following discussion of negotiations, Fisher further scrutinizes the federal government's interpretation of the written language in the treaty about hunting, fishing, and subsistence activities of the Yakama, precisely just how the government could interpret and manipulate the vague language in the treaty to express that the Indigenous had no more right to their subsistent lifestyle than non-Indigenous, and that they would be subject to penalty for breaking state hunting and fishing legislation. The Akama never gave up on their understanding of the promises as they understood them in the treaty through the 20th century, and they were willing to risk prosecution and incarceration for exercising those rights. The effect on the Akama and other Indigenous was palpable and predictable. They developed a distrust of settlers, the government, and unsurprisingly, the written record. In their eyes, they being the written record, could be easily manipulated and often manipulated to the benefit of the American government and by extension, settlers and non-Indigenous. I'll break here and we will continue with part 2. Welcome back for part 2. We'll carry on with Oral Tradition and History by Robert Lowy, written in 1917. Lowy was a philologist and anthropologist who spent time with different Indigenous tribes in the Western United States through the early 20th century and benefited from experiencing the oral tradition firsthand. The thesis of this article is that despite the accuracy of the Indigenous oral tradition, its historical significance and relevance are negligible. He compares the oral history of the Indigenous to explaining that his neighbor's cat had 4 kittens. The accuracy and truth of the statement is undebatable, but its social and cultural significance is virtually non-existent. He further supports his argument by explaining the minutiae of detail in the oral tradition and how it omits important historical and cultural events, such as the Indigenous' introduction to the use of horses or the expedition of Lewis and Clark. In his treatment of the oral tradition, he is unforgiving, and from a philologist's perspective, can find no redeeming qualities in it. His position was not unpopular if it is considered in the context of when he wrote the article. Although settlement in the Western Territory had been underway for decades, interactions between settlers and Indigenous people continued to be a novelty, and an understanding of Indigenous by European Americans had yet to develop. Interestingly, contemporary to when this article was written, in Canada, Canadian courts had found in favor of an Indigenous claim against the government of Canada. The treaty's wording and oral tradition as testimony motivated the judge's decision in the case. Chief Drever explained to the court the terms of Treaty 6, communicated to the Cree in 1876. This testimony, combined with the physical presence of the medicine chest clause in writing in the treaty, influenced the judge's decision in the case in favor of the Indigenous. The next source, Archaeology and Oral Tradition, The Scientific Importance of Dialogue by Peter M. Whiteley in 2002. Whiteley attempts to reconcile the oral tradition against the position taken by historians in the field. He argues against the view that oral tradition without archaeological support is useless, and he argues against the more progressive view by researchers like Roger Echo Hawk, who considers archaeology a cultural history. That history does not preclude the use of oral tradition in producing historical works. The climate for sensitivity in 2002 to Indigenous peoples' rights and their cultural uniqueness is compatible with consideration of oral tradition as a valid, relevant, and accurate source of historical information. Whiteley is an ethnographer, historian, and curator, as well as an expert in Native North American studies. His research includes the study of the Crow and Hopi languages and their use of the oral tradition as a means of transmission. Whiteley uses his knowledge of the Hopi oral tradition to reinforce his argument that the oral tradition is a viable source in historical research. How the Hopi remembered culturally significant villages, for example, and the explanation of the existence of their ruins in the locations they were found. He also asks a very interesting question. What makes the written record of Spanish explorers more relevant or more accurate or more acceptable or admissible even, than the oral record by the Indigenous? Each of them are going to contain their own biases and contexts that are unknown to any reader or researcher. He also discusses a conceptualization by Levi Strauss of myth versus history, that cold societies have myth and hot societies have history, and that myth or traditional histories are a sacred narrative, and that history examines the discontinuities and the differentiations between various periods. The crux of his argument is the marriage between oral tradition and conventional history as an accurate and admissible historical orthodoxy. Whiteley's defense of oral tradition coincides with Fisher's view of the spoken record as a viable, equitable source for understanding Indigenous American treaty making. He offers an example of the Hopi oral tradition of the migration between the regions of what is today the southwestern United States. This transmission and migration is archaeologically verifiable, which proves at least the accuracy of the oral tradition in the case of the Hopi. We will break here and carry on with part 3. Welcome back for part 3. We will carry on with This I Know from My Grandfather, the battle for admissibility of Indigenous oral history as proof of tribal land claims by Hope M. Babcock in 2012. Hope Babcock is a practicing lawyer who teaches environmental and natural resources law at Georgetown Law School. Babcock is a prolific journal contributor who has written on everything from Indigenous land claims to the Keystone XL pipeline more recently, as well as the use of establishing land claims based on Indigenous oral tradition. She compares Canadian acceptance of the oral tradition in the courts against American reluctance to do the same. This is based on the hearsay doctrine. More importantly, she points out the significant differences in legal understanding and general willingness to engage with Indigenous claims in good faith. Written in 2012, Babcock cites Andrew Fisher in the article to support her argument that the oral tradition is a viable source when considering Indigenous land claims or any claim within the negotiated or signed treaty. Babcock points to similar experiences between settlers in Canada and the United States. The deviation between their policies, legislation, and practice came to be because of the repatriation of the Canadian Constitution in 1982. This is when Canada legally defined the Indigenous and recognized their rights and claims related to the number of treaties signed in the 19th century. She also explains the difference between hearsay, as defined by the so-called hearsay doctrine, and how hearsay in the legal sense does not represent the oral tradition and should not disqualify oral tradition in the courts in either Canada or the United States. Babcock dives into conventional understanding of language and philology, like Andrew Fisher did. Fisher and Babcock both explained that the Western conceptualization of language differs from the Indigenous one, and they both discuss how remembering line by line or word by word holds monumentally different meanings to the Indigenous and to Europeans or North Americans. Further, Babcock also stresses that a different understanding of law and ownership played an enormous role in the misunderstanding between Indigenous of any region and the Eurocentric governments with whom they negotiated treaties. For example, Europeans thought that land was unimportant to the Indigenous because they had no legal stake in the grounds, nor did they have fences, houses, or other permanent settlements. They were nomadic after all, and Babcock explains that this nomadic lifestyle is the biggest impediment, even in Canadian law, to secure land title. Canadian common law still requires some proof or evidence that the Indigenous have occupied and utilized that land since the Confederation of the country. This is a difficult task if, say, they were forcefully removed or they maintained a nomadic lifestyle. Babcock's exploration of the subject was as intensive as Fisher's. They were working toward the same goal, to develop an equitable system for establishing ownership in a Western sense while also approaching a legal conclusion that satisfied Indigenous needs and concerns. The next source is the Anthropology of Northwest Coast Oral Traditions by Brian Thom in 2003. Brian Thom is a Canadian anthropologist whose research focuses on the political, social, and cultural processes that interpret the Indigenous title and land claims from numbered treaties signed in the 19th century and beyond. He is an associate professor in the Department of Anthropology at the University of Victoria and has played a role in negotiating claims between the Indigenous and Canadian governments. So he has firsthand experience with dealing with both sides, although that is in a contemporary sense. Central support for his argument comes from the extensive work completed by Franz Boas. Boas undertook recording many oral traditions in writing and publishing that information. His research and work began as a way to understand the movements of tribes pre-contact and offer insight into the native understanding of the world, their activities, and their interactions. Boas' works also provide an enormous opportunity to gain insight into the cultural significance of language among Indigenous people. Interestingly, Thom offers that it is not what the oral tradition contains that provides the best chance at reconciling claims or title, but the gaps in the narrative given by the storytellers. Researchers can learn what was not essential information to the Indigenous people by these gaps. Thom uses the most famous works of Franz Boas to advance his argument, as they are the most comprehensive and complete works on Indigenous linguistics. Most interesting in these texts is how closely connected language and mythology are. Most, if not all, of the criticism of Boas's work is that he did not offer enough annotations in his translations from Kwakiutl to English to make sense of the Kwakiutl mythology, a reminder of the overall significance of Indigenous language to understanding their culture and worldview. Through Boas's extensive work understanding Indigenous linguistics, researchers have developed theories regarding tribal migration, such as the Tsimshian settlement in the area they now inhabit. Although this hypothesis missed the mark in terms of scope of time, archaeological and linguistic evidence have determined the migration to be an objective fact. Thom uses Boas's research to reinforce his argument that with proper understanding of the connection between Indigenous language, mythology, and tradition in general terms, an equitable knowledge of what making treaty with settlers meant in Indigenous terms. In his discussion of the Tsimshian myths, Thom thoroughly explains the connection between myth and Indigenous conceptualizations of land, specifically the myth of, say, the coyote or the serpent, for example, brought the Tsimshian from where they were originally, and they hunted and gathered to the Pacific Northwest. Thom's research is especially salient to Andrew Fisher's research because the source material came from the region that Kwakiutl, Tsimshian, and Yamaka tribes are. That is the Pacific Northwest. Ostensibly, their oral traditions may overlap and have likely interacted with each other at some point or another. We'll take a break here and we'll carry on with part 4. Thank you and welcome back for part 4, where we carry on with decolonizing the master narrative, treaties, and other American myths. Donna Akers is an associate professor at the College of Liberal Arts at the University of Texas in Arlington. She teaches Native American history as well as women's and gender studies. Her resume is extensive, and she has taught history and Native American history for decades. In broad terms, her research focuses on Indigenous Americans, and in narrower terms, she has researched and written extensively on the Choctaw of Mississippi and Oklahoma. Researchers cite her work, aside from this article, as a method of countering the European worldview regarding common law and how it warps North American and Indigenous history and the cultural and even spiritual significance of language and oral tradition among the Indigenous. Akers offers an aggressive hot take on treaty making regarding how the United States government entered into treaties with the Indigenous tribes through the 19th century until 1871, when Congress unilaterally decided to end the practice of congressional ratification. This despite international precedent about how treaties were to be negotiated and signed. Some of these precedents were developed by the United States themselves on their own, and the treaties that they negotiated with Indigenous tribes were most often done in bad faith and against those preset rules. For example, prior to entering into treaties with Indigenous, the United States government accepted the Treaty of Ghent with the British following the Revolution. To them, the British surrender and the subsequent treaty surrendered British claim to Western lands beyond the 13 colonies. This included space occupied by the Indigenous, a principle that is based on the doctrine of discovery, a doctrine that justified settling, coercing, or taking lands from Indigenous on any continent on Earth. The Indigenous oral tradition took on a significantly different meaning in this context. Remembering the government's promises, the bribes that they were given, the violence that was threatened, and the underhanded activity taken to coerce the Indigenous into entering treaty with the United States. Akers says that the United States made it a standard practice to change treaties after signing them to suit their needs. It is only through communication of the oral tradition that some of these changes are known. The unwitting testimony of Akers' research in this article is that the oral tradition sustained the version of events offered by the Indigenous regarding American treaty making. Akers focuses far less on the oral tradition than she does on treaty making and the amendments to that practice. However, she uses information that was passed through the oral tradition to develop and support her argument. It is interesting then that I think that Fisher would have used this article as support for his own thesis if he had not written his well ahead of Akers writing hers. Before I conclude, and not begin as the slide says, the topic of oral tradition and the Indigenous experience with treaty making is fascinating. And before I conclude my discussion today, I want to offer you an opportunity to research and test the oral tradition insofar as it is impossible in a modern context and in a topical and personally relevant and meaningful way. We are having this conversation on the unceded territory of Treaty 6. We refer to it this way because the term came to us as a result of treaty negotiations and later adhesions to Treaty 6 by Indigenous people that lived here, where we're talking today. On this topic, we have an actual copy of Treaty 6 located at the U of A and available, transcribed all over the internet, a book written by Alexander Morris, The Treaties of Canada with the Indians of Manitoba and the Northwest Territories, a book by Peter Erasmus, Buffalo Days and Nights. Peter Erasmus was translator for both the Cree and the Canadian government. He was paid by both sides, as well as written versions of the oral record transmitted by descendants of the Indigenous who signed Treaty 6 with the Canadian government. This is called the Spirit of Alberta Indian Treaties. These published documents show where the oral history deviates from the treaty's contents, the government agent's sentiments, and of course, the chief translator. Of additional interest is the phrase Andrew Fisher mentions, and I've talked about it a half a dozen times myself. As long as the sun rises and the rivers flow. This actually appears in Treaty 6 in writing, codified, and where it does not appear in the Yakama Treaty, but it is mentioned numerous times in the Yakama oral record. The phrase is also present on the medals that the Cree chiefs were given as a gift from the crown upon signing the treaty. This anomaly merits further research. Specifically, how did these words travel from central Alberta and Saskatchewan to the Pacific Northwest before the internet age or before the advent of mass news media? Some final thoughts on oral tradition is that in understanding treaty making, it has been centuries since treaties have been entered into between Eurocentric governments and the Indigenous, and the centuries-old practice of treaty making is far more nuanced than Western law has managed to comprehend since colonization began in earnest. The self-styled, intelligent, and refined Europeans had no understanding of the oral tradition in Indigenous culture, nor did they make any effort to understand it. Inversely, and ironically, the Indigenous have taken to Western conceptualizations of law, treaties, and rules in an effort to retain rights they believed they were promised to them when the treaties were originally signed. In less than a generation after signing the treaty, there is evidence of Indigenous community leaders undertaking letter writing campaigns and other forms of social activism in an effort to raise awareness of their situation, proving that they're hardly the hapless savages they're painted as by colonists. They were able to quickly adapt and attempt to reconcile the rights that had been taken away from them, that had been promised to them. Now, in the terms of history, there's definitely room for oral tradition. This might come in the form of interviews with firsthand observers or participants, or in the form of elder tradition keepers sharing their experiences with their communities in the manner and tradition they always have, orally. There's a possibility, such as the case with the Iliad, for example, that archaeological evidence may be unearthed to support oral tradition. Written documents from different sources may be discovered to corroborate the version of events in the oral history, or any number of other sources that might come up and support the oral record. Accepting a single record, written or spoken, of any kind is problematic in historical research, so the oral tradition must be handled in the same way all sources are handled, with caution and care. Now, I would like to discuss a few questions, and we can talk about them as a group or answer them one at a time. Can the oral tradition of the North American Indigenous be used for understanding and interpreting treaties? Should the oral tradition be used for understanding and interpreting treaties? Is there room for a flexible application and acceptance of the oral tradition in history beyond that of myth or understanding mythologies? And how or why do you think the phrase "as long as the sun rises and the river runs" is codified in Canadian treaties, but is only present in the oral tradition of American Indigenous? Thank you.